This pre-application information session is for the Justice for Families program solicitation that was posted on or about November 7th, 2019. It is strongly recommended that you read the full solicitation prior to listening to this information session. Application submissions are due by 11:59 p.m. Eastern Time on January 8th, 2020. Applications will be submitted through grants.gov. The Justice for Families program was authorized in the Violence Against Women Reauthorization Act, VAWA, of 2013. The program supports activities to improve the capacity of communities and courts to respond to families impacted by domestic violence, dating violence, sexual assault, stalking, and in some cases child sexual abuse with court-based programs and court-related. Reset. Begin slide 3 again. The Justice for Families program was authorized in the Violence Against Women Reauthorization Act, VAWA, of 2013. The program supports activities to improve the capacity of communities and courts to respond to families impacted by domestic violence, dating violence, sexual assault, stalking, and in some cases child sexual abuse with court-based and court-related programs, supervised visitation and safe exchange by and between parents, training and technical assistance for people who work with families in the court system, civil legal services, and the provision of resources in juvenile court matters. The Justice for Families program has 8 statutory purpose areas. However, the FY 2020 JFF solicitation will only address 6 of these purpose areas. Applicants may address the following purpose areas: 1. Supervised visitation. 3. Training for court-based and court-related personnel. 4. Juvenile court resources. 5. Court and court-based programs and services. 6. Civil legal assistance. And 8. Training within civil justice system. OVW is interested in funding projects that take a coordinated approach to helping families victimized by domestic violence, sexual assault, dating violence, and stalking as they navigate the justice system. In order to help achieve this coordinated approach, applicants may propose either a standard project or a comprehensive project. A standard project. Applicants must propose activities under purpose area number 1, supervised visitation, or 5, courts. If an applicant is proposing to provide supervised visitation and or safe exchange services, purpose area 1, the applicant must also propose activities under at least 1 additional purpose area. The court's purpose area 5, can be addressed on its own or in combination with another purpose area. You may apply to any or all of the subparts of the purpose area. However, OVW will not consider applications that only propose pro se victim assistance programs under purpose area 5B or only propose education and outreach programs under purpose area 5E. Additionally, purpose areas 3 or 8 cannot be solely combined with purpose area 5E, but may be combined if other purpose areas or subparts of 5 are also applied for. A project that only proposes training and education will not be considered. Lastly, due to the restrictions on providing civil legal services, that no more than 50% of the proposed project can support civil legal services, a project cannot propose activities solely from Purpose Area 6 or Purpose Area 5B, Pro Se Victim Assistance. Comprehensive project. Applicants must propose activities under Purpose Area 1, supervised visitation, 5, courts, and 6, civil legal services. Applicants may include additional purpose areas in a comprehensive project application if they choose, but are required to include purpose areas 1, 5, and 6.
Projects addressing pro se victim service programs under Purpose Area 5B and civil legal assistance under Purpose Area 6 must count all associated costs toward the 50% cap on civil legal assistance described under Purpose Area 6 in the solicitation. A project in which the primary focus is on providing civil legal assistance is not appropriate for the Justice for Families program and will be removed from consideration and would be better suited for the OVW Legal Assistance for Victims program, which should be released on or about November 21st. Applications proposing activities in the following OVW priority areas will be given special consideration during the review process. 1. Reduce violent crime against women and promote victim safety through investing in law enforcement, increasing prosecution, and promoting effective prevention. Applications meaningfully addressing Purpose Area 5A by developing or enhancing specialized courts, consolidating courts and/or dockets, and/or creating special intake centers will receive special consideration. 2. Increase efforts to combat stalking. To receive special consideration under this priority, applicants must clearly identify how they will meaningfully engage in efforts to combat stalking. 3. Address the specific challenges that rural communities face in responding to domestic violence, dating violence, sexual assault, and stalking. To receive special consideration under this priority, applicants must clearly identify what makes the geographic service area rural and how they will address specific challenges in rural communities. The solicitation lists specific activities that are outside the scope of the Justice for Families program and will not be supported by the program's funding. Applications that propose activities that are deemed to be substantially out of scope may receive a deduction in points during the review process or may be eliminated from consideration entirely. The grant award period is 36 months. Budgets must reflect 36 months of project activity, and the total estimated funding on the SF 424 must reflect 36 months. Generally, the award period will start on October 1st, 2020. Funding levels under the Justice for Families program for FY 2020 are as follows. Standard projects, up to $550,000. Comprehensive projects, up to $650,000. OVW estimates that it will make up to 15 standard grant awards and between 3 and 7 comprehensive grant awards for an estimated $11 million. New applicants are those that have never received direct funding under the Justice for Families program, including current and former OVW safe havens and OVW courts grantees or subgrantees, or Justice for Families grantees whose previous funding expired more than 12 months ago. Continuation applicants are those that have an existing or recently closed, within the last 12 months, award under the Justice for Families program and meet the eligibility requirements. Continuation funding is not guaranteed. Please note that grant recipients that receive funding under the Justice for Families program for 36 months in fiscal year 2018 or fiscal year 2019 are not eligible to apply. OVW will not fund the same entity as either a lead recipient or grant-funded partner or subrecipient on more than 2 discretionary awards in FY 2020, absent extenuating circumstances. This award limit applies across all OVW programs, but does not include awards made for nationwide projects, such as those made under OVW's Training and Technical Assistance Initiative. Additionally, current grantees with a substantial amount of unobligated funds remaining, 50% or more of the previous award, as of March 31st, 2020, without adequate justification, may not be considered for funding or may receive a reduced award amount if selected for funding in FY 2020.
Restart. Eligible applicants are limited to states, units of local government, courts including juvenile courts, Indian tribal governments, nonprofit organizations, legal service providers, and victim service providers. Please note that a law enforcement agency is not considered a unit of local government. Also, prosecutors' offices are not considered courts and therefore cannot serve as the court partner or apply on behalf of the court. All applicants for the Justice for Families program are required to submit a certification of eligibility. Applicants proposing projects under purpose areas 1, 4, 5, or 6 will be required to submit additional certification letters. Read the Other Program Description Requirements section of the solicitation very carefully to determine which letters may be required for an application. Contact the Justice for Families program at ovw.jff@usdoj.gov if you have any questions about certification letters. All applications for the Justice for Families program must include formal partnerships with 1, a nonprofit, non-governmental, or tribal domestic violence or sexual assault victim service provider, and 2, a court. Applications that do not meet this requirement will not be eligible for the Justice for Families program funding and will be removed from consideration. Partnerships are formally demonstrated through an MOU and in some cases a letter of commitment. Here are some partnership scenarios to help determine what partnerships are required. If a court is the lead applicant, it must have a domestic violence and/or sexual assault victim service provider as a project partner. If a domestic violence and/or sexual assault victim service provider is the lead applicant, it must have a court partner. If the lead applicant is neither a domestic violence and/or sexual assault victim service provider nor a court, it must have a partnership with both a domestic violence and/or sexual assault victim service provider and a court. Applications that do not meet this requirement will not be eligible for Justice for Families program funding and will be removed from consideration. Review the eligible applicants section carefully for the definitions of court and victim service provider. Please note that a prosecutor's office is not considered a court. In addition to the definition provided in the eligible applicants section, victim service providers must also be nonprofit, non-government, or tribal entity. This does not include governmental victim service providers located within a governmental agency, police department, prosecutor's office, etc. Provide direct services to victims of sexual assault, domestic violence, dating violence, or stalking as one of their primary purposes, and have a demonstrated history of effective work in this field. Address a demonstrated need in their communities by providing services that promote the dignity and self-sufficiency of victims, improve their access to resources, and create options for victims seeking safety from the perpetrator violence and not engage in or promote activities that compromise victim safety. Under the application requirements, please note there are a few differences between standard and comprehensive projects. Standard projects have a 20-page limit, while comprehensive projects have a 25-page limit. Additionally, budgets must include funds to attend OVW-sponsored training and technical assistance in the amount of $15,000 for standard projects and $20,000 for comprehensive projects for states, and $20,000 for standard projects and $25,000 for comprehensive projects for territories, Hawaii, and Alaska.
Recipients of OVW funds must comply with applicable federal civil rights laws, which, among other things, prohibit recipients from discriminating on the basis of national origin and disability. This includes taking reasonable steps to ensure meaningful access to grantees' programs and activities for individuals with disabilities, deaf individuals, and persons with limited English proficiency. Applicants must include funds or other resources in their budget to support activities to ensure access for individuals with disabilities, deaf or hard of hearing individuals, and persons with limited English proficiency. Applicants are generally required to submit an MOU, a document containing the terms of the partnership and the roles and responsibilities between two or more parties. However, courts that are precluded from signing onto an MOU may submit letters of commitment in lieu of an MOU. Note that letters of commitment submitted in lieu of an MOU under circumstances other than those described in the solicitation will not be accepted. The solicitation provides the circumstances under which an applicant may be required to submit an MOU, letters of commitment, or both. If the court is the lead applicant and unable to sign an MOU, all project partners should submit letters of commitment and no MOU is required. If the court is a project partner and unable to sign an MOU, the lead applicant should still submit an MOU signed by the applicant and any other non-court partners, and the court partner should submit a letter of commitment. If the domestic violence and/or sexual assault victim service provider is the lead applicant and the only project partner is the court should submit a letter of commitment, but the lead applicant is not required to submit an MOU or letter of commitment. The solicitation provides detailed guidance on what an MOU and/or letters of commitment should contain, including formal partnerships with both 1, a nonprofit, non-governmental, or tribal domestic violence and/or sexual assault victim service provider, and 2, a court. Contact the Justice for Families program at ovw.jff@usdoj.gov if you have any questions about MOUs or letters of commitment. Again, applications are due by 11:59 p.m. Eastern Time on January 8, 2020. It is strongly suggested you start the submission process at least 48 hours before, but no later than 24 hours before January 8, 2020. Applications submitted after 11:59 p.m. Eastern Time on January 8, 2020 will not be considered for funding. Carefully review the charts on pages 22 through 25 of the solicitation about submission dates and times and OVW's policy on late submissions. Please review the solicitation carefully and contact the Justice for Families program with any questions regarding the solicitation by emailing ovw.jff@usdoj.gov or by calling OVW at 202-307-6026. If you need technical assistance with grants.gov, please contact the grants.gov applicant support line at 1-800-518-4726. This concludes the FY 2020 Justice for Families pre-application information session.
Stop recording.